Hey everyone, I'm David Finz, and this is a special Father's Day edition of the Cyber Insurance Imperative. As a dad and now as a grandpa, there's nothing more important to me than the safety of my family. And when it comes to protecting children online, it's not just about data privacy anymore. We need to also consider the mental health of our kids and the emotional harm that can come to children in the form of cyberbullying, body dysmorphia, and having content or products pushed on them that are just not appropriate for young minds. There's also been a sharpened focus on the dangers posed through geolocation and biometrics. These are highly sensitive data points to be collecting on minors. As a result, many states are going beyond the protections offered under the federal Children's Online Privacy Protection Act and including children up to 16 or even 18 years of age in their protection. The result is a hodgepodge of federal and state laws meant to safeguard children on websites, social media, and mobile apps. Today, I want to focus on three such new laws that will be going into effect on July 1st and give you two very simple suggestions on what your business can do to stay in compliance and out of hot water. Now, you may be familiar with the California Privacy Rights Act. Under the CPRA, a business cannot disclose the personal information of a child under the age of 16 without that child's consent. And for a child under the age of 13, the child's parent or guardian must provide that consent. But did you know that effective July 1st, the California Age Appropriate Design Code, or CAADC, goes into effect? This applies to children under the age of 18, and it's broader than the federal COPPA law. The CAADC applies to any business that is likely to be accessed by minors, and the Act requires businesses to conduct data protection impact assessments to determine any potential harm to children through the content they are exposed to or the contacts that they could make through their online activity. The California Attorney General still needs to define what constitutes harm to minors, so we will want to keep an eye on this from an enforcement standpoint. Businesses will also need to estimate the age of visitors, which in practice may result in some form of age verification being instituted for all end users. There are strict limitations on the collection of geolocation data, as well as the use of so-called dark patterns, which are techniques designed to coax children into giving up more personal information. So if your company does business in California and has a significant number of minors accessing you online, this is a new law that you'll want to watch carefully. Several states have also passed laws regulating the use of social media by minors. Florida's law takes effect also on July 1st and is considered one of the most sweeping in the country. The law extends not just to social media, but to online gaming platforms. It covers minors up to the age of 18 and tightly regulates the profiling of users as well as the processing of data. Perhaps the most notable provision is the lack of a parental consent opt-out that would exempt companies from compliance with some of these requirements. Finally, Texas also recently passed legislation targeting children's use of social media, and this law also takes effect on July 1st, 2024. Texas will now require parental consent for specific types of data collection usage. The state is also mandating that businesses develop a strategy to limit exposure to harmful content by minors and to make it easier for parents to navigate parental control settings and to monitor a child's use of social media. The bill also has provisions designed to curtail targeted advertising. Now, I promised you two suggestions on how to make sure your company is ready for these changes. And the first is to meet with qualified privacy counsel who can assess your current business practices and determine what steps you can take to stay in compliance. Need a referral? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.fins@alliant.com, and I'll be happy to refer you to several attorneys that you can vet for yourself. The second step is to check your cyber insurance policy to make sure that your coverage for regulatory proceedings is up to the task. You will want to confirm that coverage is triggered by the initiation of a proceeding by a regulatory agency for an alleged violation of privacy laws, irrespective of whether there has been a breach. It's also important to check the definition of personal information to see whether it includes biometrics and geolocation data, as well as any exclusions for the wrongful collection of information. Lastly, you're going to want coverage for fines and penalties to be determined by the laws of the jurisdiction most favorable to the insurability of such damages. These provisions could all come into play in the event that you find yourself on the receiving end of an investigation. And if your current broker isn't having these conversations with you, maybe it's time that you discover the more rewarding way to manage risk. Thanks for watching, and happy Father's Day.